Good day, everyone, and welcome everyone to the second edition of AIAC's Diversity in Arbitration Week, titled Charting the Way. Today's session is in collaboration with the Rising Arbitrators Initiative, an initiative that seeks to support and highlight young arbitrators under the age of 45. Joining me today as co-interviewer and co-interviewee is Baptiste Rigaudeau. Baptiste Rigaudeau joined LALIVE in 2018 and specializes in the areas of international arbitration with a focus on commercial and investor state disputes. He has experience working as a counsel and secretary to international arbitration tribunals under the ICC, HKIAC, SIAC, and a number of other centers. He is a member of the ICC's Commission on the Belt and Road Initiative and of the Global Steering Committee of the Chartered Institute of Arbitrators Young Members Group. He is also a member of several professional associations such as the ICC-YAF, LCIA, YIAG, and the International Wine Law Association. Baptiste Rigaudeau holds a license de droit from the University of Nantes, master's degree in international economic law from the University of Nantes, and in international arbitration and business law from the University of Versailles. He also holds an LLM from Cardiff University Law School. And now introducing the man of the hour, Mr. James Ding, the interviewee for today. Mr. James is a partner of Tay Partners in Kuala Lumpur and acts mainly as counsel in litigation and arbitration matters, particularly in construction disputes. For the past 14 years, he has sat as an adjudicator with the Asian International Arbitration Center, also known as the KLRCA. James is a barrister at law in Lincoln Spain and an advocate and solicitor at the High Court of Malaya. He holds a master's in law for international dispute resolution from Queen Mary University of London, a master's in law from the University of Malaya, and a master's in science in construction contract management from University Technology Malaysia. He is currently pursuing his PhD in arbitration at University of Malaya. James holds fellowships with the Singapore Institute of Arbitrators, the Asian Institute of Alternative Dispute Resolution, Malaysian Institute of Arbitrators, and the Bali International Arbitration and Mediation Center. Thank you so much, James, for joining us today.
Thank you, Nadhirah, for that lovely introduction. And it's good to see you here, Baptiste, as well.
Good to see you too. I think the task is for me to ask you the first question as co-interviewer. So let's get started then. So the first question shouldn't be difficult, and that is, what inspired you to pursue a career in arbitration, and how would you describe your journey to date?
Thank you, Baptiste, for that question. I trained initially as a civil and commercial lawyer when I developed an interest in construction law. This led to me joining an established construction set here in Kuala Lumpur before venturing out on my own and in partnership to focus primarily on construction dispute resolutions, both in terms of litigation and arbitration as well. Now, I see arbitration as a very practical and a very flexible dispute resolution mechanism, and I'm keen to see arbitration being further expanded in terms of its usage in this arena. Now, what inspired me is because I've learned throughout my career as a lawyer, it's that resolving a dispute does not mean that one has to jump straight into the dispute resolution mechanism straight away, but to see how middle grounds can be achieved between two disputing parties. Now, this can be a challenge because coming from a common law trained lawyer, we are primarily trained to defend the client's right fervently. So it's all too easy for the arbitration or the final determination method to come into play right from the start. However, with ADR, there can be various forms such as we know, mediation, and a hybrid form of ADR such as MET-UP, a combination of mediation and arbitration, which to my mind plays a vital role in identifying areas where the parties can work on to see if a middle grounds can be achieved. And for areas that ultimately no middle ground can be achieved, we still have arbitration there to resolve all disputes. Now, as counsel, I would describe my journey so far to be an interesting challenge. Understanding the crux of the issue is given, but all the other aspects of the arbitration proceedings, from the preparation of the documents to the cross-examination of the witnesses, and usually that's where the true picture of the circumstances will usually be revealed, to me has been an enigmatic and exciting process. So I hope that this will continue, as I having seen that in my career thus far.
Thank you, James, for that very exciting answer. I think it's a new perspective to hear that your journey into alternative dispute resolution is more than just arbitration centered. Baptiste, can you share with us a little bit on what inspired you to start a career in arbitration?
I guess what inspired me was that I wanted to work in an international environment since I had pursued international studies. As you mentioned in Cardiff, and I also wanted to work on different topics and industries. I didn't see myself as focusing on one particular topic at law school. To explore other topics, I wanted diversity and to be able to learn new things all the time, which is what I'm doing right now. So check. I also wanted to do disputes work and to argue one side, to find counter arguments, anticipate the other side's arguments, and most importantly, persuade and convince a tribunal. And so now my journey to date has been international, to say the least. In the last 10 years, I've worked in 4 different cities, in 3 different continents: Hong Kong, Houston, Paris, and now Geneva. My journey, I would say, has been about people. I've met incredible people intellectually, but also humanly, people that care about others and care about seeing others succeed. And of course, I've worked on incredible cases that have made me discover all types of interesting sectors and issues. Different issues as different as gold mining, conservation of biodiversity, or the production of wine. And thanks to those cases and the clients for which we brought them, I have lived wonderful experiences, especially during hearings.
Thank you so much for sharing that with us. I think what we can take away from that is that arbitration is such a broad spectrum of law that you can really delve into anything. And so I think the next question for James is that, considering the fact that arbitration is so broad and the issues at hand can be so diverse, what are 5 skills that you think any arbitration practitioner should have before or they should develop when they join this industry?
Thanks, Nadhirah. 5 skills that any arbitration practitioner should have. I would say the first is preparation. 2 is simplification. Understanding the client's needs as opposed to what they want. Knowing when to push or stop. And to appreciate what the other side is saying or where they are coming from. Now, just to expand a bit, I'm not going to talk about preparation because I think that is something very fundamental and basic to be prepared with your case. The simplification, I am a big proponent of trying to say things simply. If I can shorten a paragraph into a sentence, that's what I will do. In terms of clients' needs, everybody wants to win. Even the practitioner wants to win. But also knowing where the other side is coming from, the type of evidence that they have, also will teach us when to stop certain arguments or when to push certain arguments or points forward. I think this is crucial. In the backdrop, we also need to understand who is the deciding person, be it the judge or the arbitrator. And this can be gleaned from their legal training, can be gleaned from the previous decisions that they have decided upon. And this gives us a great insight to help us prepare for the approach in framing the case or the situation for the clients. Now, with all these skills, yes, sure, you won't win all the time, but at the end of the day, the clients that you meet will feel satisfied because they know that where you're coming from and that they know that you care for their matter. And I think these are very important attributes.
Agreed. So the next question is for you again, James, and it's although you're yet to secure your first arbitral appointment and you've acted as adjudicator, what are your thoughts on transitioning from an arbitration lawyer to an arbitrator, so an arbitration counsel to an arbitrator? And specifically, what sorts of matters do you believe one needs to turn their mind to when wearing these different hats?
Okay, thanks, Baptiste, for that question. Now, coming from the perspective of an adjudicator, which I have had the opportunity to write several adjudication decisions, and at least the similarity in terms of an arbitral award and adjudication decision, I would say that there is a noticeable difference between a counsel and an arbitrator. Now, as counsel, you may say that you're only obliged to advance your client's case and put it in the best possible light, while addressing why the other side's arguments are just utterly and sadly wrong. Now, as an adjudicator, and in which case I believe as well as an arbitrator, one has to balance, oftentimes, extreme views from both sides, which is a lot easier said than done. Furthermore, arbitration inevitably has oral hearings. So having an even temperament is one of the key factors to ensure a smooth and timely completion of these oral hearings. Again, it sounds easy, but in reality, it's often not the case, as parties or in fact, the arbitral tribunal might be perhaps subconsciously aware with the potential excess of jurisdiction or breach of natural justice arguments that seem to be very typically advanced by the losing party. So there may be some concern on that part. So these are the things that I feel that transitioning to becoming an arbitrator has to have that ability to balance the views between both sides in a fair manner, as well as at the same time having this even temperament in terms of coordinating the oral hearings, particularly the oral hearings of the arbitration, but generally as the whole.
Thank you so much for the answer, James. I think, Baptiste, you're in the same situation as James, where you've acted as counsel a great many times, but you're still waiting on your first arbitration appointment. So what do you think from your perspective, what are your thoughts on transitioning from one hat to the other?
Thanks, Nadhirah. I would agree with what James said. I think when you're transitioning, I mean, when you're gearing up towards appointment as arbitrator, I think you need to be aware that once you're appointed and wear the arbitrator hat or cap, you undertake a duty to both parties, not just one now, to consider their arguments fairly and to deliver a decision about which they can say, okay, my points were duly considered and weighed, and even though I may not have won or may not have won fully, I know I was given a fair chance. You also need to understand that you have to be efficient and you have to render your decision swiftly. But in my mind, you also have to be humble about the issues. And if they require time to understand and take a good decision, then while informing the parties of your progress, you have to take your time and don't rush to a decision. You also need to uphold, of course, the highest standards of ethics, especially with respect to conflict of interest, because once you're an arbitrator, you're responsible for the integrity of the process as a whole and of your award, of course. Last, as young arbitrators, I think we need to be creative in using case management techniques to allow for a quicker and more efficient resolution of the disputes. And we must not hesitate to use these new case management techniques in consultation with the parties to be proactive and really take ownership of the case as arbitrators. I would also argue that as arbitrator, you still have to remember your counsel days, to have in mind the issues counsel run into, and to make sure you do not impose impossible deadlines or commitments to counsel, for example.
Then I think coming from the background of a counsel and jumping into an arbitrator as an arbitrator.
Yeah, for sure. So the next question to James is in line of that that question is what value do you believe young lawyers and young arbitrators bring to the table?
Thank you, Baptiste. When the term age diversity, when we're talking about younger practitioners or younger lawyers to that mind, in my humble view, it is about having diverse perspectives. Now, it can be from the legal angle, or it can even be for working experience across the ages. Today, as we know, technology is always changing. And sometimes it's impossible even for the younger ones to keep up with at all the time. But there are many advantages for the younger qualified arbitrators or practitioners to sit as arbitrators. Coupled with the fact of greater enthusiasm and drive, generally there will be a better adaptability of technology towards the preparation and conduct of such arbitral proceedings. Like you said, Baptiste, adapting to the new technology will greatly improve the efficacy as well as to the cost of the arbitral proceedings, in my view. So this is important because we are going through a global pandemic now, and the use of this technology in arbitration is now a necessity rather than optional. So being a younger practitioner in this, we generally have a better adaptability towards this modern technology. And this is something that can be vastly contributory in a positive way towards arbitration, the starting, the execution, and the completion of such arbitrations around the world.
I definitely think adaptability is relevant more now than ever, especially as we face this global pandemic. So another question for James. So what advice would you give to young lawyers that want to break into the area of international arbitration, or even to seasoned veterans seeking to transition into the area of arbitration, particularly those from Malaysia and Asia?
Okay, thanks Nadhirah for the question. My humble view is that it's all about having exposure to arbitration. Participation in conferences and initiatives in the field of arbitration is one of the key factors, I would say. Another possibility is to explore it to further postgraduate studies if there are opportunities for that. And it's really a good way to be involved, to know the framework of arbitration. Although I like to caution that by completing these postgraduate studies, and there are many around the world today, it does not automatically on its own makes a graduate an arbitrator straight away. So there is some caveats when I say that. But fundamentally, it comes down to the individual, and one of the things that it will take time. Have a positive outlook, but at the same time, have a realistic expectations. If I can put it in another way, I would say treat it like a passionate hobby. So in terms of appointments, if it comes, then congratulations. But if not, then all is still well and good.
I agree, James. Patience is key to break into arbitration. And everything happens, it's sometimes just the question of being at the right time, right place. But being patient is key. So what are your thoughts, James, on initiatives such as the AIAC's Diversity in Arbitration Week in promoting age diversity in international arbitration?
Yeah, thanks, Baptiste. The topics on diversity, be it to gender, age, cultures, are extremely important, and it should be a continuous conversation in any context. Biasness in terms of age, gender, qualifications, cultures, or race, to name a few, is not going to go away with just one or two initiatives. It has to be a long-term conversation that hopefully leads to a better understanding. And if we truly want to be that broader change and involvement, then we all have to be a part of that continuing conversation. For this, I truly applaud the AIAC for being the mover of this initiative, together as well also with the Rising Arbitrators Initiative. And I'm truly humbled to be here today to be part of this conversation.
We're very honored to have you, James. And I think if we can just direct the same question to Baptiste, like, what are your thoughts on these kinds of initiatives and these kinds of efforts in giving a platform to better raise awareness regarding the diversity of international arbitration?
Well, my thought is that they're great. Otherwise, I wouldn't be there. And I'm really thankful to have been able to discuss with James and you about what it means to be a young arbitrator. And this initiative in particular made it happen, this dialogue across regions. Of course, as you know, institutions play a huge part in promoting diversity, age diversity, racial diversity, social diversity. Institutions have a big part to play, and they do play it more and more. And so by these initiatives, they raise the awareness that young arbitrators are also a commodity that is somewhat underused. And thanks for that. I would say the arbitration pie is large enough for everyone, and a lot of success in achieving a career in arbitration depends on the access to the pie. And the AIAC initiative is great to provide that access. And of course, I would be remiss not to remember that the Rising Arbitrators Initiative is also that knowledge sharing initiative that is accessible to everyone. So again, feel free to go to the website and see what events are available to you and how you can take ownership of these resources to construct your career in arbitration.
And I'll just add to say that I second what Baptiste just said as well.
Definitely. Thank you so much, Baptiste, for what you said. I think definitely a large part of ensuring diversity, more than even just these panels, is the intentional way we make our appointments, the intentional way we craft our panels, and the way we include people from more marginalized groups into the activities and the things we do as an arbitral community, more than anything. So I think that since that is our last question, I'd just like to thank both of you so much for this amazing interview of your day to join us today and to support this initiative in collaboration between the AIAC and the RAI. Thank you again, Baptiste and James, and I hope you all have a good evening.
Thank you very much, Nadhirah, and to the whole team from the AIAC there as well, and also to record my thanks to the RAI as well.
Likewise. Thank you so much.
Thank you.